Okay, let's get started. Welcome, everybody, to our 16th episode of Commercial Collection Agencies of America's 20-Minute Talks. I am so proud to continue the legacy of Umberto Matz from Creditors Adjustment Bureau. It was his idea, and it has just taken off wonderfully. So, welcome to everybody. If you are new, a special welcome. We open up the 20-minute talks to all of our colleagues in the industries. So I'm really happy to see some non-CCA of A members. I would encourage you to check this out if you like this. There's more where it came from at conferences um, and the education. We have three agencies that I saw on the attendance list. So a special welcome to the non-CCA of A members. I will also remind you that we have a very impressive library. Now, here's the hook. The non-members have to become members to have access to the library. So please, for members, avail yourself of all of the 20-minute talks. If you weren't able to attend all of them, they are on the website and they're accessible through your login. And I would be remiss to tell you that we are less than 3 weeks out from our semi-annual meeting in Austin, Texas, where we are going to take education like we are offering you today, and we are going to amplify that into 2.5 days of continuing education for agencies and CLEs, continuing legal education for our attorney members. So if you have not registered, we still have room. The hotel, we sold out of our block 2 or 3 times, but they still have rooms available. So if you can make it to Austin, April 19th through the 22nd, we're staying at the Driscoll Hotel, and there's some excellent education planned. This time I'm going to turn it over to CCA of A President Alex Rosen, who is going to introduce today's speaker.
Thank you, Annette. I'm pleased to introduce my friend, Vivian Uchitel. Vivian was born in Charleston, South Carolina, and grew up in Augusta, Georgia. She graduated cum laude from the University of Georgia in 2001 with a Bachelor of Science in Psychology and a minor in biology. After graduating, she earned her Juris Doctor from Mercer University School of Law in Macomb, Georgia in 2006, and went on to begin her career as a staff attorney for the Honorable David Darden State Court of Cobb County. Following her clerkship, Vivian focused her entire career representing creditors, both large and small, across the United States and internationally, and litigates claims throughout the entire state of Georgia. She formed Vivian Hudson Uchitel Law, LLC, in 2024 to continue her passion in her practice areas of expertise, including commercial, contract, and account litigation, creditors' rights in bankruptcy, insurance premium litigation, garnishment litigation, personal property foreclosure actions, commercial landlord representation, foreign judgment domestication actions, general civil litigation, and appellate practice. Vivian focuses on all stages of collection, from the initial demand to post-judgment remedies to ensure maximum collections. Prior to establishing her own firm, Vivian co-founded Simpson, Uchitel, and Wilson, LLP in 2012 after 5 years of practice as an associate and senior associate at Simpson Law Office. Vivian lives in the Atlanta area with her husband and 2 boys. She's an avid runner and enjoys cooking and spending time with friends and family in her spare time. Vivian, take it away.
Good afternoon, everyone. Thank you for taking the time from your busy day to join us for this 20-minute talk. Many thanks to Annette for allowing me the opportunity to speak to you all today, and to Alex for the introduction. The title of this 20-minute talk is, Why Hasn't My Judgment Been Entered and/or Collected Yet? We all have clients with unreasonable expectations regarding the litigation and collection process. These unreasonable expectations are largely the result of not fully understanding issues that arise during litigation and collection that are outside of our control. I am presenting this topic today to provide insight into common issues attorneys encounter during litigation and post-judgment collection. Agencies are the front line when it comes to interfacing with clients, and my goal today is to equip you all with better tools to temper client expectations. Now, this discussion is premised on Georgia law, the Georgia court systems, and what my firm experiences during litigation and post-judgment collection. However, the challenges my firm faces in Georgia are likely similar to what other attorneys experience around the country. So the first questions clients ask are, what is the timeline for recovery once a claim is placed in legal, and how much will it cost? Well, recovery can take 1 month, 1 year, or not at all if we deem the claim uncollectible. Getting clients to understand that claims may not be collectible can be a tall order, but I believe it should be communicated on the front end as a way of tempering expectations. As far as expenses are concerned, my firm typically requests a $550 cost advance. A simple collection case typically costs $750 in Georgia to file and serve a lawsuit, obtain judgment, and file 1 bank garnishment. These costs increase with multiple service attempts, extensive discovery, etc. Now, when a claim is placed with my firm, we make written demand within 5 to 7 days of acknowledging the claim. We make phone calls within 7 to 10 days after sending written demand. Our suit recommendations are sent within 30 days after the claim is placed. Now, once a claim is placed in legal, our goal is to file suit as quickly as possible if we deem the matter collection worthy. The agencies have done a lot of the collection legwork before the claim came to us. So once it's placed in legal, a lawsuit is typically necessary for recovery. So how long can a client expect a lawsuit to take before judgment is entered? Well, it can take 4 months to a year or more. The first step to getting to your judgment is filing suit in the county where the debtor resides. Now, there are 159 counties in Georgia, and each county has its own operating procedures. Fun fact I learned while preparing for this talk, Georgia has the second most counties of all states behind Texas. My firm handles claims against debtors throughout the entire state. So my assistants must call clerks in counties where we don't typically file to determine if the judges in that county want us to provide courtesy copies of motions, proposed orders, or whether we can simply e-file and expect orders to be entered. Also, my assistants have to call because costs can vary from county to county. It's just not uniform throughout all the counties. Okay, so now once you've filed your lawsuit, what's next? You have to serve the lawsuit. Individuals can only be served in Georgia personally, notoriously, or by publication, but only if you have testimony from a sheriff's deputy or a process server that debtor is evading service. Service on a corporation or an LLC must be through a registered agent, officer, or a managing agent thereof. So what is the timeline for obtaining service? The best case scenario is approximately 4 weeks, but there are a number of obstacles that we have in obtaining service, such as service on individuals not authorized to accept service on individuals that don't reside with the debtor, private process servers that can't get past gates, or debtors evading service. But by far the most frustrating is service on someone who is not authorized to accept service. For example, we sue ABC Company and the registered agent is Joe Smith. Sheriff's deputy goes out to serve ABC Company, but instead of serving the registered agent Joe Smith, he instead serves Joe Smith's wife, Jane Smith. Jane Smith has no affiliation with the company other than being Joe Smith's wife. This isn't proper service. So then we have to send it back to the sheriff's department to reserve with instructions only to serve Joe Smith. If you try to push your judgment through based on bad service, what's going to happen is someone's going to come in and try to set aside your judgment. So you might as well go ahead and take that extra step. Another obstacle that we face are sheriff's departments sitting on complaints because of backlog or not enough manpower. Some counties, we must mail service requests, and we all know how terrible the USPS is these days. In some cases, the sheriff's department must also mail the entry of service form back to our office, which causes further delays. We also have unreasonable timelines imposed by judges for perfecting service. We have some judges in certain counties who are dismissing cases unilaterally and without any notice after 3 months of filing, regardless of what the circumstances are. Some judges don't care, or maybe they don't know that the sheriff's department is backlogged, or that the sheriff's department does not put civil service at the top of their priority list. Judges really care about docket control, and dismissing cases due to lack of service is a way of docket control for them. So why don't we just hire a private process server to bypass the sheriff's department? In Georgia, a private process server must be appointed by the court the case is filed in to serve a Georgia resident. Now, in larger counties in the metro Atlanta area, private process servers obtain appointments that can last a year. For all other counties that are not in the metro Atlanta area, we must file a motion to have that process server appointed. It can take weeks for the order to be signed. Also, we may not be able to find someone to serve in remote rural areas. So what happens if you can't get service? Well, you can't move forward with your case. Okay, so what happens after service? In Georgia, you have 45 days to file an answer. If there's no answer that's filed, it goes into default. If there's an answer, litigation begins. So let's focus on no answer first. We go and we move for a default judgment. The timeline for obtaining judgment, best case scenario, is about 4 to 6 weeks. There are some courts where the judges are on top of their docket and enter judgments very quickly, and there's some that do not. We have a lot of obstacles in obtaining default judgments. Not all courts operate the same way or have the same staffing. So there are some judges in rural Georgia who he doesn't have a staff attorney or a judicial assistant, so he's entering all the orders and writing them himself. There are some judges in Georgia that treat default damages as unliquidated damages, requiring a testimony and hearing to prove damages. In these cases, we have to get an affidavit from the client, we have to show up at court, and it can take months before we get our judgment. There are some counties where we file a motion for default judgment in January, but a hearing isn't set until June, and we have no control over that. Some judges sit on motions for default for months despite calls, emails, and repeat filings. And unfortunately, this is far and few, but is very few of these, but there are some jurisdictions where we must associate local counsel to push cases through. Okay, so now let's move to what happens when an answer is filed. That's when the 6-month discovery period begins in Georgia. During this time, we engage in discovery, file procedural motions, and dispositive motions. Collection cases are by and large motion practice. Litigants have 30 days to respond to motions in Georgia. The most common motion that we file is called the Eccles motion. In Georgia, a corporation or an LLC must be represented by counsel, but very frequently the owner or the registered agent will file an answer on behalf of the company. Once we file our Eccles motion, they'll have 30 days to respond. After that 30 days, it's very common for judges to enter orders allowing them another 30 days, another 45 days to retain counsel. There are also some judges that will schedule a hearing, make us show up and argue a motion that should be granted summarily, and then allow the debtor an additional time to go retain counsel. So these are just a few variables that we can't control. Now, counterclaims delay the entry of judgment because now, in addition to proving your own claim, you have to also get the counterclaim dismissed. And sometimes extensive discovery is necessary when a counterclaim is filed. So if we can't get our judgment through procedural motions and we go through discovery, that's when we file a summary judgment motion. On a summary judgment motion, we have to prove that no genuine issue of fact exists. We have to get a business records affidavit from the client, and then the debtor has 30 days to respond. Hearings are often necessary for summary judgment motions so that we can explain to the judge why there's no issue of fact. So what happens if summary judgment is denied? Well, typically we try to go through mediation if it's a simple collection case, which requires client participation. If we can't get it settled through mediation, that's when the case is scheduled for trial. It could be 3 months after summary judgment is denied or more. And of course, a client must send a witness to testify. Now, some courts in Georgia enter scheduling orders providing timelines for discovery, mediation, filing dispositive motions, and when trial will be scheduled, but by and large, courts don't really enter scheduling orders. Okay, so now let's turn to what happens when we get our judgment. Clients must understand that getting judgment does not always equal collection. The timeline, 3 months to a year after judgment is entered, or not at all if we deem a judgment uncollectible. The most common collection avenue in Georgia are bank and wage garnishments. Once you file a bank garnishment or a wage garnishment, it must be served just like a regular lawsuit through a sheriff or private process server. Now in Georgia, a bank has 15 days to answer and another 15 days to open the default if they do not answer, so they have a total of 30 days. An employer has 45 days to answer and another 15 days to open the default, so a total of 60. If money is paid into the registry of the court, Georgia law requires the court to hold the funds for 20 days after the answer is filed and money is paid in. Once the answer is filed, money is paid, and 20 days pass, it can take an additional 4 weeks or more before the court cuts and mails the check. I get calls and emails all the time from clients and agencies that are frustrated. They're like, why haven't we gotten the money in? And unfortunately, the garnishment process in Georgia is lengthy. So from the time of filing the garnishment, you're looking at least 3 months before my firm receives the garnishment disbursement. So what happens if a client doesn't have banking information? We must locate a tax identification number or social security number, and we can run a bank search. It typically takes about 30 days to obtain the results of a bank search. If we don't have any banking information and our bank search comes up dry, we can then send post-judgment subpoenas to financial institutions or secured creditors. First thing we do is we pull a credit report, or we go to the UCC financing. There's an index from the Georgia, it's called the GSCCCA, where we can actually log on and we can find all the UCC filings. So then we can send discovery to, if we find a mortgage company or we find a financial institution on the credit report, we then send the discovery to that financial institution and they have 30 days to respond. If they don't respond, you have to either send a letter or you have to resend the discovery. And it's very common for a financial institution to not send the responses within the 30 days. It's typically about 60 days. We can also send post-judgment discovery directly to the debtor, but the discovery is almost always ignored, and it requires motions to compel and motions for contempt. Another collection avenue in Georgia, liens, real property and personal property liens on automobiles. You first have to request the lien for real property from the court that issues the judgment. Then the lien must be recorded on the real estate docket. This can take weeks or months depending on the court. Liens on automobiles. We first have to send the request to the Georgia Department of Revenue, and this process can take anywhere from 30 to 90 days. I always say it depends on who opens the mail that day. And then if we do get title information back from the Georgia Department of Revenue for our debtor, we can then begin the lien application process. This takes anywhere from 90 to 120 days or more. So with liens, you're looking at anywhere from 6 months to 9 months before you get your lien. All right, now turning to obstacles to collection. Motions to set aside judgment. So you send your demand letter to the debtor. He doesn't respond. You file a lawsuit. He doesn't file an answer to the lawsuit. And then you get your judgment and you pop a garnishment. And lo and behold, it retains counsel and he files a motion to set aside your judgment. Well, if you have a bank garnishment pending and you've got money in a registry, that case is going to be stayed pending the outcome of that motion to set aside judgment. And as I said before, you have 30 days to respond to a motion, and then likely you're going to have a hearing on it. Another obstacle that delays collection, obviously insolvency, or if you can't locate leads for collection. I routinely pull credit reports with 450 credit scores, all charged off accounts, and tell clients, look, there's nothing I can do at this point. If I can't locate any other leads, there's no bank accounts, it's time to shut it down. And of course, the most common, bankruptcy. So how can clients help expedite getting to judgment and collection? Providing all supporting documents to agencies when placing the claim, including any financial information on file for the debtor. I think we talk about this at every conference, but I can't stress this point enough. When clients fail to provide documentation, it not only delays collection, but it can also prevent us from recovering all amounts the client may be entitled to if contracts, credit applications, etc., are omitted. There's been several instances where I'll get a judgment against an LLC. I'll send the judgment to the agency. The agency will send it to the client, and the client will turn around and say, well, where's my judgment against the personal guarantor? And I'll tell the agency, well, they didn't provide any documentation regarding a personal guarantee. So that's why they don't have. So then you have to file a new lawsuit for the personal guarantor. Another thing that can help is providing legible documents. If I can't read it, I certainly can't explain it to a judge. Timely responding to inquiries. If I go 30, 60 days out where a client isn't responding, I usually reach out to the agency and say, hey, can we please set up a conference call? Timely returning required documents such as verifications, affidavits, responses to discovery. Not having timely return documents will delay getting your judgment. Then also timely providing suit requirements. And the last point I try to make is to try to tell clients to not become emotionally invested in the case and or the outcome, because neither the agency nor the attorneys can guarantee collection. So this concludes my presentation today. I hope that the information provided has been helpful, and I welcome any questions you may have.
So if anybody wants to question, please put it in the chat. Vivian, I have a couple questions. And
Sure.
I had like 6 questions and you answered 3 of them. So, but first a comment, and I sound like a broken record, but the timely transference of giving information, right? So make sure that you are responding to your attorney's requests. Agencies, make sure that, when they're asking you for information, make sure to turn it over. But also in conjunction with that, make sure your client is giving updated information. The worst thing is that when you have a judgment, I know I say this a lot, but when you have a judgment and you've got a credit app that's like 7 to 10 years old, most likely, that debtor is a debtor for a reason. Most likely that bank account is going to be closed. And it's the biggest drag for the attorney because they've went to all of this, the expense and the work, and you've got a judgment and you've got an old bank account.
Mhm.
So, and I know that's the age-old question about, like getting with sales and of your client and making sure we have updates. So let's see what we've got. Alex, do you want to ask your question?
Yeah, sure. Vivian, so I heard you describe that you usually request 550 in fees up
Yes.
front, but also that it's about 750 to go through pre-judgment and then initiate a bank
Mhm.
garnishment post. Isn't it kind of annoying to request fees on multiple instances, and why not just throw 750 from the start?
Because 750 shies, it makes people scared of actually proceeding. And 750 isn't always the case. Okay, so if it's less than $15,000, you can file a bank garnishment in magistrate court in Georgia. So it's cheaper. It's only $90. But if your case is over $15,000, then you have to file in state court, which it ups it to about $300. So, and then what happens if you get your judgment and you don't have any banking information, or maybe the client just wants to get the judgment and shut it down? 550 will get you there. But again, I think if you tell people 750, client's going to be like, I don't want to file suit. That's too much.
Gotcha. So it kind of bleeds into my second question, although tying in what you just said, sounds like it might be a 50-50 in terms of the need for 550 or 750, and to support the volume or activity, 550 might make sense initially for all involved.
Mhm.
My other question is like the percent of cases that go without an answer towards default versus the ones that do answer. I presume it's more like an 80-20 thing where it's a default no answer situation.
That's correct. I would say somewhere around 80-20 or 75-25, something like that.
Okay. Thanks.
But like I said, there are a lot of instances where you get your judgment, you pop a garnishment, and then they try to set aside the judgment.
Right.
Vivian, if you get a judgment against, or if you get a judgment and then you do a wage garnishment and the company doesn't answer, I know in some states you can get a judgment against that employer. Is that the case in Georgia as well?
That is a great question, Annette. Yes. So with banks, the banks have 30 days to respond. If they don't respond, you can go ahead and file your motion for default judgment. If you get your judgment, you then have to personally serve the bank with the judgment through the sheriff or a private process server. They then have 90 days as a matter of right to modify that judgment, meaning they can file something with the court saying, hey, the debtor didn't have any money at the time. Here's the cost for the garnishment, and they can modify that judgment. So the same thing with the employer. If they don't file an answer within 60 days, you can go ahead and apply for your judgment. You have to serve them. They have 90 days to modify as a matter of right. In fact, I've just gotten 2 judgments against banks just in the past couple of weeks.
Okay. All right,
Mhm.
that's interesting. Robert Ash asks, have you ever tried to lien or levy a debtor's website or levy their revenue payments a debtor may be receiving via their website?
I haven't done that, but I can tell you that I used to do some collection work for um, radio stations, or I'm sorry, not for radio stations, for people that have judgments against radio stations. And what I would do is I would garnish their advertisers. I would sit there and listen to whoever was
I
running
love that. That's creative
commercials.
judgment.
So, I mean, I guess that's maybe along a similar vein, but no, I've never tried the collection route that Robert was talking about.
And then similar, I don't know which Julie Rosen this is because we have 12 of them, but it's have you ever successfully attempted to levy on Square or other point of sale platforms
I
like
have not
Square,
actually,
PayPal?
I take that back. I have tried levying payment process companies. It's been a while though, and they were successful with restaurants and things of that nature that owed money for food, but it's been a while.
Let's see, when you run a credit report, do you subpoena creditors' records for applications and copies of the last payments in order to obtain banking information?
With respect to credit applications and things of that nature and mortgage applications, it depends on how old they are. If they're going to be 10 years old, if I'm looking at a credit report and that trade line was open 10 years ago, no, I'm not going to request that information because it's not going to be current. But if it's something that was open currently, yes, I would request that information.
Okay, and then Tom had a question. Do you encourage or discourage agencies from suggesting conference calls with you as the counsel and the client and the agency? Let's say there's something to discuss. You would be open to that.
Absolutely.
Yeah.
Absolutely.
That transparent communication, I think, is what sets the affiliate attorneys of CCA of A apart from all the others. They're just so helpful, and um there's always something that they have to offer. Brian will ask Vivian about that. And if she would like to supply it, we'll put it along in the library. Um, any other questions? All right. All right. Okay, now here's a challenge for everybody on the call. The first one to put the correct answer in the chat is going to get a free Commercial Collection Training Institute course. It's worth $100. All right, you ready? How many counties are there in Georgia? Wait, it's a two-part. And Georgia is second to what state? Free CCA. Oh my gosh. Look at rocks. Wow. 159 in Texas. Roxanne Sizowski from Altus. Very good. Very good. Well, I'm sure Alex will join me in saying, Vivian, this has been very, very
Great.
informative. I love these 20-minute talks. Non-members, if you like what you see, contact me. You have my email, contact me. We would love to talk to you about membership. Members, if you have missed a 20-minute talk, feel free to access previous talks in the library and save the date, May 7th. Chip Stacy is actually on here. He said first any day in the first week of May. So May 7th, Chip Stacy, SL Law Group in Arkansas. So I thank you very much for everybody, and especially to Alex and especially to Vivian. Thank you for joining us today, and everybody have a great rest of the week.
Thank you, and thank you for the opportunity. I appreciate it.
Oh,
Thanks, Vivian.
wonderful. Thank you.
Thank
Have a
you.
wonderful day.
Good job, Vivian.
All right, thank you. Bye.
Thanks, guys.
Bye, everyone.